Hi everyone. My name is Nakia Matthews. I'm one of the senior legal ethics counsel at the DC Bar. There are four of us. I'll let my colleague Courtney introduce herself.
Hi, everyone. My name is Courtney Thomas. I am one of the legal ethics counsel at the DC Bar as well. Nice to meet everyone. Well, virtually meet everyone.
And Rashee, everyone knows you, but you have a fancy new title, so I'm not
Yeah.
sure.
Yeah, my name is Rashee Raj. I am the former general counsel at BEGA, but about 10 days ago, I got sworn in as an ALJ at the Office of Administrative Hearings. So um, that's the new thing. But I promised I would do this. So
We greatly appreciate it.
yeah, of course.
We would have missed you.
Just because you leave ethics doesn't mean you stop loving ethics. Okay, I
uh,
should mute myself now.
that's okay. Um, so I'm not sure. Can you all see the like little box at the top? Or just the screen? Okay, that's just me. All right. Um, so we at the ethics program like to say that kind of ethics exists, well, the rules of professional conduct exist in kind of a larger context. And so um, the DC Bar does provide one part of that, and BEGA provides the other. And so we have at the DC Bar several ways for you to get legal ethics guidance. One is from the legal ethics opinions that are issued by the committee, the Legal Ethics Committee. Those opinions are not binding on the court. They are, unlike Virginia and other jurisdictions where the court approves those opinions once they are issued. Our opinions are persuasive guidance. Then there is also the Legal Ethics Helpline. You can email us or call us Monday through Friday, 9 a.m. to 5 p.m. We're available for questions. Our guidance, again, does not bind the court or disciplinary counsel. But we strive to ensure that it's in line with what the court and ODC gives out in terms of guidance themselves through either their court orders and sometimes disciplinary counsel. They'll write articles. We do have conversations with them about their positions on certain things. Even though, again, when you call us, it's a confidential helpline. We cannot and do not disclose any of your information. You can also reach out to BEGA, and we often tell individuals who call from the government to reach out to your agency. In DC, you're fortunate to have BEGA. You can also reach out to OAG as well. Um, in DC, the rules are promulgated by the DC Court of Appeals, and the Office of Disciplinary Counsel is the entity that essentially investigates and prosecutes lawyers for violations of the rules. Recently on the helpline, I've been getting a lot of calls about the ODC process. And so since anyone can file a complaint, you can file a complaint. Usually it would probably be done through your agency, but if there's a complaint filed against you, we've been getting a lot of questions about that particular process. And I've been getting a lot of questions coming from like family members that have gone rogue and they want to file complaints against another family member or a friend that they know is a lawyer or spouses. And so I think that sometimes it's just good to remind people about the process um, with ODC. A complaint does not automatically become public. So if a complaint is ever filed against you, that complaint is sent to you. You're allowed to respond to that complaint. And it's only after the investigative process and if the case is docketed for actual prosecution, that it becomes public information and publicly available. Rashee, I don't know if you want to talk about a little bit about BEGA's resources or
Oh, sure.
how they can contact BEGA for assistance.
Yeah. Well, you are always welcome to contact us. If you have a favorite attorney, you can reach out to that person, or you can reach out to bega@dc.gov, or you could call There's an anonymous tip line if that's the route you need to go. But we are always here for you, and it's better to ask before than after.
Just set that.
So- Sorry, is there a question? Okay. I'll also just highlight that the guidance that we give on the helpline is prospective. So if there's something that, just piggybacking off of what Rashee says, if there's conduct that has already occurred, we tend to not give guidance about that. Our guidance is going to be, you're probably at the point where you need to call a professional responsibility attorney because you're going to probably be in need of actual advice.
Yeah.
And, always like you want your clients to come to you at the beginning of the problem. It's probably better to do that. So our guidance is always going to be prospective. We don't weigh in on matters that are already in litigation or conduct that has already occurred. We're really kind of come to us at the beginning of the issue.
Yeah, same. But if you come to BEGA before the issue, your binding or your the ethics advice that you receive is safe harbor. So if you need government ethics advice, definitely come to us and get that. I keep saying us.
It's still a part of BEGA. Darren still, is always BEGA, even though he's not technically there anymore. So I think you guys have a far-reaching community over there.
Yeah.
Okay. Let me go to the next screen. Sorry for the technical difficulties, guys. For some reason, it's not, okay. Still not letting me do it.
Anything I can do?
Okay. No, I think it's good now. It's letting me do something. Okay, so we talked about that. Okay, so I'm not sure if you all know, but there were recently quite a bit of changes made to the rules of professional conduct. There was the first round of changes that were made. The order came down in April and it became effective May 6th. There were changes and additions to Rule 1.1 competency, Rule 1.6 confidentiality, 3.8 special responsibilities of prosecutors, and Rule 4.4 respect for rights of third persons, and Rule 5.3 responsibilities regarding non-lawyer assistance. So I've linked the order below. The changes, I think, are already up. Well, they are already up on the DC Bar website where you can view the rules. But if you like to kind of look at what the changes were, the DC Court of Appeals order has both the red line and clean versions for you to take a look at. Okay. So there was two sets of rules changes. I'm going to talk about one set, and then Courtney will talk about the other set. So with respect to Rule 1.1, the competency, Rule 1.1 competency, the changes that were made were adding comment 5, which talks about procedures and technology. Now, this really just codified the guidance that we always gave, which is, lawyers, when you use certain technology, you are responsible for ensuring that it is in line with the rules of professional conduct. So that means that you are protecting client information, that you are handling it in a manner that you don't need to know how things work, but you need to know essentially where the information is being stored. Is it protected? So you don't have to know, again, the algorithm, like how the algorithm works, but you need to know, for instance, like if you're using a chat GPT, the free version versus the business version, is that information being stored? How is it being used? So that you can make decisions as to whether or not to use that product or use kind of another version of the software. 1.6 in line with that was also changed to ensure that lawyers are taking reasonable steps to prevent disclosure of confidences and secrets. This kind of ties in with the changes to Rule 1.1 because a lot of this comes down to technology and making sure that you're protecting client information and, again, the way that it's stored. Comment 40 really gives a lot more clarification. If you're in the private sector and you're representing Google, the type of software that you use to protect client information is going to be a lot different than, if you're a solo practitioner. If you're in the government, you have the extra protection of, in-house IT, but you also want to make sure that if you're using any personal devices, if you're forwarding emails to your personal emails or to you ever like forget your work computer and you use your personal computer, you want to make sure that you are just cognizant of the technology and the way that you use it and protecting the client information. So 3.8 was really drastically overhauled. I've noted here that there was a separate court order. So the order that was issued in April, there was an error in that particular order. The order from July 21st, 2025 clarifies language in that order. And it was just a small change, but it was a really impactful change. So the court issued a supplemental order. So if you weren't aware of that, you may want to take a look at the supplemental order as well. But a lot of the changes that were made to 3.8 were essentially codifying in Ray Klein and ensuring that the guidance that is given in the comments and in the actual black letter of the rule are in line with that. So, specifically Section D about not failing, making sure that you're not intentionally failing to disclose impeachment information, ensuring that you are not delaying the process. And then again, those are in line with the comments changes to subsection H and I. The comments, especially 4 through 7, really go into great detail about the special responsibilities of prosecutors and ensuring that in the comments there is adequate guidance about the core values and principles that those prosecutors must carry with them. And then 4.4, this was the other substantial change to the rule, in part because the court sua sponte added subpart C. So 4.4 deals with respect for rights of third persons. This is essentially the rule that we go to like when you are inadvertent disclosure rule. So if you inadvertently send documents to, it used to just be, as you can see in comment 2, it used to just be an adversary, but the court changed the language to say from another attorney. So, if you want to read it to its potential logical conclusion, if you and your friend went to law school together and you're typing something in, you mean to send discovery to someone else, but they have the same name as your friend and you send it to that attorney, that friend who's also an attorney, they would have the responsibility to comply with 4.4. So a huge one is that, again, previously it was just an adversary, now it's another attorney. And then the other big one is that 4.4C gives guidance as to what you're supposed to do if you are in the middle of reading a document and you realize that it was inadvertently disclosed. So the prior version of the rule, there was kind of this bright line of before you read the document and after you read the document. So if you look at the document and you can kind of tell on its face that it was a document that wasn't responsive to discovery, something that you didn't request, something that contained client confidential information for the opposing side, you were responsible for not reading it, picking up the phone, calling the attorney who sent it and say, hey, did you mean to send this to me? And then if they said, oh, you're right, I'm sorry, please destroy it, delete it. You are responsible for doing that. And then the previous rule, again, the bright line was before and after. So after is like, after you've read it, oh, well, I've read it. I have this information. You can't unring the bell. You kind of can't unsee what you just saw. So the rules say you can use it, of course, if the court says that you can use it. So you can attempt to use it. You can retain that information for your memory, for your motions, for whatever you need to do, unless the, claiming the privilege and all of that is kind of in the hands of the trier of fact. Well, 4.4C gives this kind of middle of the road version. So there's a before you read it, while you're reading it, and an after you've read it. And 4.4C essentially says if you're reading it and you realize they didn't mean to send it to you, you need to still call them, say, hey, I was reading this document, you sent it to me, did you mean to send this to me? And then if they said, no, please destroy it, you're required to follow those directions. We will note that comment 4 sets the limitations and boundaries of 4.4, and that's essentially the way of saying, like, the rules are not going to get into whether or not you can actually use this at trial. Again, it kind of sets forth that we're just saying it's ethical to use it, or it's when it's ethical to use it, when it's ethical not to use it, what you must do. But whether or not after you've retained that information, if you've already started reading it or if you read all of it, whether or not you can use it at trial is actually a question for the court. The boundaries of 4.4 are just purely ethical, whether it's ethical or not. Courtney, I will turn it over to you.
Okay, thank you very much. So I'm going to go over the rules that changed effective September 5th, 2025. And in this PowerPoint slide, you should be able to see at the very bottom, we do have the link for the order that was entered by the court. So you can kind of get a better understanding or a better idea of what the court was thinking, some of the comments that were provided in response to the rules. But the main rules that were changed in September is Rule 1.6B. So there's some additional language there. There's also a new comment. There's also a change to comment 25 under Rule 1.7. Rule 1.16 has some additional language, 1.6D specifically, Rule 1.16D specifically. And then there are some changes to Rule 5.6 as well. And then going over to slide 13. Perfect, thanks. Okay, so Rule 1.6B, there's some additional language that kind of clarifies what's considered a secret and what's not considered a secret under 1.16. So we know 1.16 originally talks about what needs to be held confidential, specifically client confidences and secrets. And we know secrets are any information that's gained in the course of the representation that the client wants either not disclosed or that could be detrimental or embarrassing to the client. Well, the change here is there's some additional language added that states a secret generally does not refer to legal knowledge or legal research, to knowledge that the lawyer has obtained about the regulatory environment in which a client operates, or to information that is generally known in the local community or in the trade field or profession to which the information relates. Right, so it's saying we don't have to protect, or the attorney does not have to protect or keep confidential legal knowledge, legal research, etc. There's also an addition to comment 41 under 1.6. That additional comment states agreements that restrict the subsequent use of information that is not a client secret or a can raise concerns about the general ability of clients to obtain lawyers and the ability of lawyers to represent other clients competently and zealously. So they're just wanting to caution you that these agreements could be viewed or should be viewed with caution. So you just really want to make sure that you're not expanding too much with these agreements between yourself and a client. So those are the key changes under 1.6. And then moving over to 1.7 that talks about conflicts, there was a change specifically to comment 25. So comment 25 under 1.7 did allow for an attorney and a client to agree to additional restrictions on the attorney that didn't or weren't present in the original rule under 1.7. However, the court determined that could unnecessarily impede on the ability for attorneys to be able to represent other clients. So they changed or amended comment 25 to now read that agreements between a lawyer and a client precluding representation of other clients in circumstances that do not preclude representation under 1.7 through 1.12 or 1.12 will not expand the scope of those rules. So those are the key changes. And again, you can look if you go to that DCA or that district Court of Appeals order that was linked in the previous slide. You can kind of get an understanding. There was a lot of conversation and discussion about, what the why that rule changed and why it was necessary to change that rule. Going over to slide 14. So Rule 1.16, subsection D, actually got a new addition, and that addition states that it's not misconduct for a lawyer to retain copies of documents relating to a client. So we know normally under 1.16D, there's a requirement that once an attorney terminates or there's an end of the representation of a client, that attorney should return all of the client's documents, return the file to them, surrender any papers, money, information to that client. However, you can retain copies of that document. The court went further to clarify as well in comment 12 that the information contained in those copies of client documents retained by the lawyer following the conclusion of a representation may not be revealed or used where such revelation or use is prohibited by Rule 1.6 or other of these rules, 1.9, 1.7, or 3.3. So again, you're allowed to keep those copies for your own records, but you still have to make sure that you're safeguarding those copies and you're wanting to make sure that you are not disclosing those. And it looks like we have a question. Let me see. Is there a limit or can you keep them indefinitely? So there's no, under comment 12 and under 1.16D, there's no mention of a limit on how long you keep that information, as long as you're, again, keeping those documents, you're safeguarding those documents, and you're not using them in violation of 1.6. There's no mention of a time limit there. I mean, there is some mention of how long you should retain documents in your possession. I think I think it's in a legal ethics opinion, or it might be in one of the comments, but it does give you, I think it's under 1.15, but there is that 5-year term before you can destroy any documents. So, keep that in mind. But just if you're keeping or retaining copies of old client files, you're just going to want to make sure that you are holding them safely.
And Courtney, I'll just say that there is no statute of limitations on bar complaints. And so if you believe that there is an issue, like if you had a particularly difficult client or something that went awry, like you may want to make sure that you can hold on to that file indefinitely, because there is no statute of limitations on prosecution from the Office of Disciplinary Counsel.
Point. Thank you, Nakia. And it looks like I answered that we answered that question, so I'll move on to Rule 5.6. So 5.6 does have a change to comment 4, which states, although a lawyer may agree to work exclusively on behalf of a single client for a given period, in light of the strong policy in favor of providing free choice of counsel, outside of such an exclusive relationship, a lawyer should not agree to restrictions a client seeks to place on a lawyer's ability to represent other individuals or entities whose representation is not otherwise precluded by these rules if those restrictions would unduly interfere with the general ability of clients to obtain lawyers or the lawyer's ability to engage in public service or would undermine the integrity of the profession. So again, you can work exclusively. There is an understanding that that could happen, but you just want to make sure that you're not, again, restricting your right to practice, restricting the client's right to have counsel of their choosing. So you're going to just want to make sure that you understand that. There's also this case that's cited, the Jacobson Holman PLLC v. Gettner case. So you can look there if you want some additional explanation on that comment or Rule 5.6. And then the last rule change, it addresses pro bono service, and that's going to be Rule 6.1. And that states a lawyer should participate in serving those persons or groups of persons who are unable to pay all or a portion of reasonable attorney's fees or who are otherwise unable to obtain counsel. A lawyer may discharge this responsibility by providing professional services at no fee or at a substantially reduced fee to persons or groups who are unable to afford or obtain counsel or by active participation in the work of organizations that provide legal services to them. When personal representation is not feasible, a lawyer may discharge this responsibility by providing financial support for organizations that provide legal representation to those unable to obtain counsel. That is the pro bono change. There's also a couple of notes in slide 16 on pro bono service, just to keep in mind if you do engage in that, if you're not going to take the financial route and you do want to provide those services, you just want to make sure that you understand that the rules of professional conduct do apply to your pro bono representation. And that also includes, any assistance that you provide to family, friends, even if they're not paying you, those rules of professional conduct still apply to you. You also want to make sure that you're aware if you are assisting friends or relatives, or if you are trying to do some, pro bono voluntary work in other jurisdictions, that you're aware that, writing demand letters or even making calls to people could be or could trigger issues under Rule 5.5, specifically the unauthorized practice of law, and could trigger some issues under 4.2, which is communication between a lawyer and a person represented by counsel. So you really want to make sure that you're keeping that in mind. If you're trying to, assist someone in another jurisdiction, whether that's a family member or anything else, you want to make sure that you're checking with that other state and see what their rules on unauthorized practice of law says, because if it's okay with that jurisdiction, then under Rule 5.5, under the DC rules of professional conduct, that it should be okay with DC. So you want to check with that the outside jurisdiction first to make sure that you're in compliance with Rule 5.5 here in DC. Let's see. Oh yeah, there is a gray square in the slide. I don't know. I know it goes away, it kind of goes in and out. I don't know if that's just a WebEx issue, but we'll try to resolve that.
I'm going to try to stop the presentation, like stop sharing it and then reshare it and see if there's an issue. If that resolves it. Okay.
While we're redoing that, I had just put a note in there to see also DC Official Code 1-1162.23A, the pro bono legal representation part of the Ethics Act, which is relatively new, and talks a little bit about who you can and cannot represent as a DC government attorney.
Thank you. Yes, thank you for that. And I think it looks like we were able to get the slide back without the gray boxes. I did just want to touch on the last point, which were there are some provisions of Rule 6.5 that provide less restrictive conflicts checks for short-term pro bono work taken through a court program or a nonprofit association. So make sure you just take a look at Rule 6.5 as well if you're engaging in pro bono work. So those are the changes that were effective in September, and now we have some hypotheticals that we want to get into. And Nakia and I are going to kind of go back and forth, but Nakia will start with the first hypo, so I will turn it back over to her.
Okay. So Lucas works as an attorney advisor for the DC Department of Buildings. Lucas also serves on the expansion committee of his church. The committee has been asked to review, can't see something, sorry. It has been asked to review and provide guidance to the church on building contracts and zoning ordinances. Before he joined DOB, Lucas was in private practice and the church was one of his clients. He has not represented the church since he left private practice. Are there any precautions that Lucas should take while a member of this committee? So A, no, it is not the practice of law and he is doing a good deed. Or B, yes, he should set clear boundaries regarding his participation. And I'll just give like a second or two. I see the answers coming in. Most of them are B. So BEGA should be happy. All of you seem to know the ethics rules and are ethics gurus. So I'll just go on to the next slide. So the best answer is B. Yes, he should set clear boundaries regarding his participation. And this is in part based on Rule 5.7, which is responsibilities regarding law-related services. One of our colleagues, Saul Singer, wrote an article a long time ago that I still refer people to. It's called like May a Lawyer Build a Deck. And so, lawyers have side hustles. They, build decks or, have tax preparation services or, do a million other things. And the rules recognize that. It's just important to ensure that there are clear boundaries set. And so the person knows when you're acting as a lawyer and when you're not acting as a lawyer. Do those rules of 1.6 protect the conversations that they are having with you, or if they do not. It also helps lawyers because if the rules apply, that means the conflicts rules like Rule 1.7 apply and could, really restrict your, side hustle or your side business more than is necessary, maybe under the rules of that particular business. I know that Rashee, and I don't know if you wanted to talk about these particular rules.
Yeah, the rules that are probably implicated here is the pro bono legal representation, one that I put in the chat a little bit earlier as far as who you can represent. Outside employment rules, outside activity, because this would be an outside activity even regardless of the amount of pay. And then the conflict of interest statute, just to make sure that your new client isn't somebody who is against the district.
Courtney?
Yes. Okay. So question 2, Laura works as an attorney advisor for a DC government agency. She's traveling out of the country for a family vacation. She's only taking her personal electronics, but does she need to take steps to protect any of her agency's information that may be on her personal electronics? So there's A, yes, she must take reasonable care to prevent the unauthorized access of client information. Or B, no, that is why Laura did not bring a work computer or her work phone. So I'm gonna give you a minute, but I mean, it's just a tons of A's. So I think we all are on the same page on this one as well, which is really, really good to see that. Yes, the best answer is A, that yes, she must take reasonable care to prevent the unauthorized access of client information. Um,
So I'll say technically both answers were A because there's a typo. So
Yes, and
you
I so
couldn't get
sorry.
it wrong.
They said it was two A's,
Um,
so I mean, you got it right either way, whether you picked um one or the other. But yes, so it's A. Yes, she must take reasonable care to prevent the unauthorized access of client information, and that is based on Rule 1.6, subsection F, which states a lawyer shall exercise reasonable care to prevent, specifically subsection 2, the unauthorized access to client to confidences or secrets of the client. And then comment 40, which touches on that as well. When transmitting or storing confidences or secrets of a client, the lawyer must take reasonable precautions to prevent the information from coming into the hands of unintended recipients. And we also included in the next slide, if you want some additional information, or if you want to hear really what I thought was a really good and interesting podcast episode. Nakia Matthews is actually featured in that podcast episode. It's called The Tea on International Arbitration. It was recorded or released July 21st, 2025. And it's knowing your obligations and rights in securing privileged and confidential information at the U.S. border. I mean, I'm sure if you've seen the news or, read it, seen it, you've heard of different people having like their electronics and things searched when they're coming in and out of, or coming back from out of the country. And if you're an attorney, that's something that you just want to make, something that you may want to keep in mind, and listening to that podcast could be helpful and shed some light and, give you some information that you might not have had. And it's really interesting, a really interesting listen.
and I'll just say the people that were on the podcast with me were the interesting part. I just talked about Rule 1.6 was one a former undersecretary for Homeland Security, and another was a data
Hmm.
technology attorney who does a lot of international travel, and so they gave really good practical advice and practical steps that you should take. So the plug is to listen to it for them because I learned a lot from them that particular day. Rashi, I think there are some questions in the
Yeah, I
chat.
think my part might
Sorry.
address those. Um, Also, I think I believe you're going to get a PDF of the slides at the end, so you should be able to click on that link when you receive it, so you can go directly to that. So, as far as ethics rules, we'll look at government property. Oh, I guess this one isn't government property really because it's her device. Um, but then you might want to also look at Octo's rules regarding using your personal devices. I saw that Alexander said, I thought DC policy prohibited doing work on your personal devices, which I kind of thought so too, but it seems like a lot of people do it, or maybe their office doesn't provide them a device, so they use their own just to be able to be more responsive. And it's not necessarily prohibited by the ethics rules. It could be, I mean, it could be violating other rules depending on what sort of confidential information you have on your device or you have access to. Yeah, that's exactly what Marie Claire said. I would be scared about what you would be able to FOIA from the device when it's your personal one. Um, let's see, Kate had a question too for this hypo. Do we assume that the information on their personal devices are authorized to be on their personal devices? I'm not sure. I am not sure, but I guess if it was, you would have to go through that process with Octo, where you can get VPN access to travel internationally if you need it. So you would have to go through that process, which I'm sure it's on like start.dc.gov, and then you request it and your supervisor has to approve it. So somebody has to know that you're doing it and approve it for you.
I would say from the rules of professional conduct, you can assume that it is or isn't, because the rules wouldn't really speak to whether your employee allows it or not. I guess there might be other rules that are implicated in that, maybe some of our 20, especially depending upon what you have on there, it could implicate some of the other rules of professional conduct, but specifically 1.6 doesn't really, is kind of neutral on whether or not you're allowed to have it. Okay, so Warren is a lawyer for the Office of the Attorney General. He and some friends had dinner. Warren had 5 drinks with his dinner. As he is arriving home, he hits a parked car. The police were called and Warren was arrested. He has not been convicted. Warren tells his coworker Shirley, who is also a supervising lawyer at OAG, and his friend, although she is not his supervisor, what happened. Under the rules of professional conduct, does Shirley have a mandatory duty to report what Warren did to the Office of Disciplinary Counsel? A, yes, there is a mandatory duty to report. B, no, there is no mandatory duty to report. So we have it's kind of a mixed bag. I see some A's and some B's. I'll give it another second. And so best answer is B. No, there is no mandatory duty to report to the Office of Disciplinary Counsel. So 8.4B says that it's professional misconduct for a lawyer to engage in a criminal act that reflects adversely on the lawyer's trustworthiness, fitness, or fitness as a lawyer in other respects. So if there were, and I should have taken this rule first. So the mandatory reporting rule has kind of 3 parts to it. A lawyer must know. And so that's actual knowledge or what can be inferred from the facts at that lawyer's disposal, that there is a violation of the rules of, so 2, that there's a violation of a rule of professional conduct, and then 3, that it goes to the lawyer's honesty, trustworthiness, or fitness in other respects. So in this situation, going back, Shirley knows that there's been a issue, right? But when we look at 8.4B, because you need a violation of the rules. So the violation of the rules that would take part here would be a criminal act. But that criminal act has to reflect on the lawyer's honesty, trustworthy, fitness of that particular lawyer. So the reason why we give the best answer is no is because technically Warren had 5 drinks, but we don't know when he had those 5 drinks, the interval. Like there's a lot of things that could be inferred. Was he actually over the limit? We don't know at that particular time. So technically, there's no criminal act. You could go a little bit deeper and kind of argue, even if there was a criminal act, does it go to his honesty, trustworthiness, or his fitness as a lawyer? Does he have a problem for which he needs help with? And so it's not reflective of who he truly is, but maybe just having a moment of problems, and he may need more assistance, and that's not truly reflective of his work. Does it actually impact his work? So there are a lot of questions that are left kind of unanswered by the hypo. And because of that, which often happens many times in the questions that we get on the helpline, is even if you have the no, you still have to have all 3 elements in order to report the lawyer's misconduct. And so again, that's the, well, very clear. Now, if Warren bribed the officer, then yes, I think that actually, then right? If he says, hey, Shirley, I gave the officer $100, I showed him that I worked for OAG and he kind of went away, then you have 8.4, because he confessed and told you. And so you have all 3 elements present, but you need to just make sure that you are, when these questions arise, number one, I assume that your agency, if it's dealing with something that's intra-agency or, that your agency has policies in terms of how they want those issues handled. But outside of that, when you're considering it for yourself or you're calling the helpline, we're going to talk to you about whether those three elements are truly present, and whether or not it actually is a mandatory report scenario.
Okay, can y'all hear me? DC Wi-Fi is really failing me today, and was sounding choppy for a minute. So hopefully the sound quality is good. And there are some code of conduct rules that are implicated when a crime is committed. So if you'll take a look at 1800.3 M and N, among other ones, these two probably go directly to it as far as employees shall adhere to all federal, state, and local laws and regulations. So looks like it's possible he didn't hear, so you could make that referral to us. If there's a criminal case pending, it's possible, that BEGA will wait for that to play out before something happens, but it's also possible not. So I guess if it was not a crime that was committed, there's also the appearance that you're violating the law. So that could also be an issue.
Okay. Courtney, before you go on to Hypo 4, because I know we're getting close to the mark, and I don't know if some people have to jump off. We have the CLE code for the DC bar. It is XG82. Again, XG82. Thank you, Marie Claire.
Okay. So question 4, so we have the same facts as question 3, but the question now is, does Shirley have a mandatory duty to report Warren's arrest and incident to OAG? And answer A is no, because Warren's conduct does not violate 8.3 or 8.4. Or B, yes, because Shirley now needs to take into account the interests of the OAG as her client. Okay, so I'm going to give you guys a minute. Looks like we're getting a couple different answers. So I see a couple A's, lots of B's. Okay. So the best answer to that is actually going to be B. So the best answer is B, and yes, because Shirley now needs to take into account the interests of the OAG as her client, and that's the key, right? So the answer is B, because under Rule 1.13, subsection B, if a lawyer for an organization knows that an officer, employee, or other person associated with the organization is engaged in action, intends to act, or refuses to act in a manner related to the representation that is a violation of the legal obligation or a violation of law, which reasonably might be imputed to the organization and is likely to result in a substantial injury to the organization, the lawyer shall proceed as reasonably necessary in the best interest of the organization. Unless the lawyer reasonably believes that it is not necessarily in the best interest of the organization to do so, the lawyer shall refer the matter to a higher authority in the organization, including, if warranted by the circumstances, to the highest authority that can act on behalf of the organization as determined by applicable law. So, yeah, so Shirley should make that report, should report that either to the higher authority within the organization or whoever is appropriate for her, or who has been deemed appropriate for her to report that incident to. I don't see, I know I did see a question about the CLE form, and I think we were just trying to wait to see if we can get some feedback on that, and we hopefully could circle back to answer that question. But I will move on to question 5 and let Nakia take that one.
Okay, to whom should Shirley make the report? A, BEGA, B, OAG, Human Resources, C, Warren Supervising Attorney, D, the Office of the Inspector General. So I see a lot of C's, some B's, some C's. Okay. So most of the answers are C. So we'll go ahead. The best answer is yes, Warren's supervising attorney. Because ultimately, you know, that supervising attorney is the one that is somewhat responsible for Warren, and ensuring that both that she is supervising Warren, getting him potentially the assistance that he needs, but she also has her own duties to her client, the agency. And so that would be the best person to report, uh, for Shirley to report the issues to. And then our last hypo.
Okay, yes. So Larry left his attorney position with the DC Department of Insurance, Securities, and Banking to join the faculty of a law school clinic. He would like to file an amicus brief on a matter that he worked on behalf of, hold on, sorry, one second. Sorry about that. He would like to file an amicus brief on a matter that he worked on while at DISB on behalf of the law school clinic. Under the rules of professional conduct, can Larry file this amicus brief? A, yes, he can file the brief because he is not working for another client. Or B, no, he cannot file the brief because it is filed in connection with his new private employment. I'm going to give you guys a minute to chime in with the answer for that one. Okay, I'm seeing lots of B's. I think almost all B's, which is really great. So yes, the answer to question 6 is, or the best answer is B. No, he cannot file the brief because it is filed in connection with his new private employment. And that's really great. So it sounds like everyone is familiar with Rule 1.11, which talks about successive government and private employment. Specifically, we're talking about 1.11a. A lawyer shall not accept other employment in connection with a matter which is the same as or substantially related to a matter in which the lawyer has participated personally and substantially as a public officer or employee. Such participation includes writing on the merits of a matter in a judicial or other adjudicative capacity. And yes, in this hypo and hypo 6, because we have Larry, he worked specifically with this matter while he was with DISB. He cannot then file this brief in his new employment because it is a matter that it appears based on the facts that he would have substantially and personally been involved with in his government work, and likely is substantially related as well. So that's why there would be a bar there. I don't know. Do we want to talk about
I think we're at 11:30. I
yeah.
know there's another session, so I think we can, there, the information is available in your materials. There's ethics opinions and other information. Really, if you have a Rule 11 question, it's best to probably give us a call because they're just so nuanced and the answer is really going to be based on your particular situation and scenario.
Same
I
thing for
will,
government ethics. We recommend you call, you have free post-employment advice from us for the rest of your life if you need it.
I also give the CLE credit a code, sorry, again, XG as in George 82. I was not able to get an answer about where you get the MCLE form from. Um, but if you want to send me an email, I'll make sure you get it. My email is NL Matthews with an S, two T's, so NLMATTHEWS at dcbar.org. So if you don't receive it after this email from CLE or you have a question about where to get it from, just shoot me an email and I'll make sure that you get it.
Thanks, everyone.
Thank you all.
See you on the next one.